be seated. We'll hear argument in 240162, Paxton against American Oversight.
May it please the court, Ms. Klusmann will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court. American Oversight's mandamus petitions should be dismissed for 2 reasons. First, as this court recognized in Sharp, district courts do not have jurisdiction to entertain mandamus petitions against the governor and the attorney general. That jurisdiction has been removed. The amendment to the PIA did not put it back. Second, American Oversight's disbelief that it has received all responsive and non-privileged documents does not create mandamus jurisdiction. The role of courts under the PIA is not simply to double check that the governmental entity has fully complied with all its duties merely because the requester asks it to do so. For these 2 reasons, we ask that this court would render judgment dismissing the mandamus petitions. I'd like to begin by discussing which court, if any, has jurisdiction over the mandamus petitions against the governor and the attorney general. And of course, our background is the decision in Sharp, which recognized that while the Constitution grants general mandamus authority to district courts, it also allows the legislature to remove that authority. And it did so with respect to these 6 constitutional executive officers in the Government Code 22.002C. And so essentially, we have general jurisdiction. The Government Code carved out this bit, and the question in this case is, does 321B of the PIA carve out a piece of that initial carve out?
Would the result be different, do you think, if the legislature had used language other than mandamus to describe the action that they're offering to people in this situation?
Yes, Your Honor. So for example, enacted in 1999, Section 3215 of the PIA permits a declaratory or injunctive action to be brought against a governmental body. And so you don't have that mandamus issue that you do with respect to 22002, which specifically says mandamus petitions against these officers. The exclusive jurisdiction is essentially in this court.
So for purposes of records held by the Office of Attorney General, how do we distinguish between the Attorney General and the Attorney General's office?
It's the choice of who you sue, I think, is the answer. If you have sued the Attorney General in his official capacity, 22.002C kicks in. Now, we also have what the court stated in Sharp, which is it doesn't really make a lot of sense. I think the court used the word unworkable to sue what the governmental body for mandamus relief under the PIA, because it is the individual who is responsible for responding. And as the court recognized, that doesn't really matter in most cases because the district court's going to have jurisdiction over either one, so you can name either party. But when it comes to these 6 constitutional officers, it does matter because the officer himself has to be, mandamus jurisdiction would be in this court. I should also add with the caveat with the
could they
exception of
just
the
send
governor.
another open records request directed to the OAG and for the same stuff? When the OAG says, we've given you all we have, then they can file a declaratory judgment action against the OAG?
Well, under 3215, the declaratory judgment action would be filed by the Travis County District Attorney. It creates a process for a requester to complain to a local district attorney, and then that district attorney or county attorney has the authority.
The requestor cannot file the declaratory judgment action.
That's not how I read 3215.
That is how you read 3215 to mean that the requestor cannot.
Correct. It is an action brought by the district or county attorney. It's actually specified in that
So the
process.
only kind of action that the PIA allows a requestor to bring is a mandamus action.
Correct, Your Honor.
Do we have any indication of why they denominated this action as a mandamus petition?
I mean, that's the one, as I think I just explained with Justice Boyd, that is their only option unless they wish to go through the Travis County District
I mean
Attorney.
why the legislature described it as a mandamus petition. There's no obvious reason to me why they would have chosen that
No,
that
I
way
mean,
of describing the action.
I didn't trace this all the way back. I assume it's existed since the PIA was adopted, and they just chose the mandamus vehicle. Maybe they wanted it to be something more, the mandamus obviously brings in this idea of a clear abuse of discretion, and so maybe they wanted something a little bit beyond just maybe there's a document out there, it needs to be a clear abuse of discretion on behalf of the government. That might be why they did it. I couldn't say for sure why they did, though.
Or perhaps they wanted to incorporate some of the jurisdictional limitations on mandamus actions.
That would be a better answer from my perspective,
I don't
Your
know.
Honor, yes. But yes, I mean, the jurisdictional provision that puts these 6 officers in this court, I believe, goes back to at least 1925, and so that's just been a long-standing part of Texas law, that these 6 officers, mandamus petitions against them are filed in this court.
So under the Constitution, where it's Section 3, jurisdiction of the Supreme Court, and this under A, the last sentence, the legislature may confer original jurisdiction on the Supreme Court to issue writs of quo warranto and mandamus in such cases as may be specified except as against the governor. Isn't that really getting into the ability of the legislature to confer original jurisdiction?
Yes, that is, yes.
And so what bearing does that have on your argument generally as far as what, the legislature did, if it's really confining to that idea of original jurisdiction?
Well, and because this is an original jurisdiction case, 22002C says that only the Supreme Court has authority to issue a writ of mandamus against any of the officers of the executive department. So that falls right within there. That is, 22.002A gives the court the authority to issue writs of mandamus against officials, and then 002C makes that jurisdiction in this court exclusive with respect to these 6 individuals. Again, of course, though, then carving out the governor, which no court has now the jurisdiction to issue mandamus against.
So leaving aside the governor, say he was not a party to the action, could this very action have been, would you concede there'd be jurisdiction here, again, leaving aside sovereign immunity, but jurisdiction here if the action had been filed here?
Sure, I think that's what the Sharp case was. It was, except that was against the comptroller. So you would file your original mandamus petition against the Attorney General in this court, and then of course you would have the questions of, is there a fact issue which would preclude this court from resolving the mandamus petition, and of course our second argument that they certainly haven't alleged sufficient refusal to produce documents.
Point 321 talks about a mandamus against the governmental body. Why isn't this, why shouldn't this be considered as a mandamus action against the OAG and therefore not subject to the limitations on mandamus actions against the constitutional officer?
Because number one, they filed it against the constitutional officer, not against the office. And then I guess we go back to what this court said in Sharp, that the mandamus should be filed against the officer because the officer is the one with the obligation to respond.
But the statute speaks of the governmental body.
Yes.
Not of the officer.
Correct. And if we follow that train of thought, then the fact that they sued the officer means that 321 doesn't govern here. It doesn't create mandamus
Which kind of
jurisdiction.
gets me back to what I was wondering before, which is what if they refiled it but named the OAG as the defendant, as the governmental body?
Mm-hmm. Well, and then I said, again, this comes back to what the court said in Sharp. Can you do that? Can you mandamus a governmental body when the official is the one under the PIA who is obligated to respond? And that's something the court pointed out was unworkable under the PIA. And the legislature essentially doubled down on that in 1999 when it added subsection B, and it continued to refer to the governmental body, which is, I think, one piece of evidence that the legislature was not, in fact, responding to the Sharp decision when it added subsection B, because it left that problem in place. It did not fix that, especially with respect to these 6 individuals.
And also, if you buy the notion that there's a coherent distinction between the elected officer and the governmental body, and then you just have an order against the governmental body, the officer is in charge of the governmental body, and so what obligation would he or she have to do the thing that you've ordered the governmental body to do, since you've distinguished between those two and you haven't ordered the officer to do anything? The officer says, I'm in charge of this, and you haven't ordered me to do anything.
Right. I think that was why the court called it unworkable in Sharp. And so it's just, there is a distinction between the two in the law. The legislature keeps referring to governmental body, and 2202C carves out officials, these 6 officials, and they've brought a mandamus petition against these 6 officials. So that's where we are.
So your position is that even if the office was the named respondent, in the trial court, that wouldn't work either. Because it has to, because the officer has to, is responsible for responding.
We would, I imagine we would make that argument, and then this court would, or if it made it all the way up here, would have to decide if what it said in Sharp is in fact true. You can't mandamus the body, you have to mandamus the official who's in charge of
There's
responding.
hundreds of employees in the Office of the Attorney General.
But only one is in charge of responding under the PIA. It's the
Right.
chief administrative, or, the buck stops with the Attorney General, essentially. So you can only
Your
mandamus
position is
him.
basically any public information request propounded to any, about any case, anywhere, involving any government official that works for the Attorney General, would have to be brought here in the Texas Supreme Court, because the Attorney General, as the state officer, is the respondent.
I mean, you make that sound.
That was the dissent in Sharp, and did the legislature try to fix that?
I have not, what I see is that the legislature created a method for district and county attorneys to bring similar things in district courts. But I also haven't seen an overwhelming number of mandamus petitions filed against the Attorney General in this court. I have a feeling my office would have been involved in that in some way. And so it hasn't turned into this problem that the dissent in Sharp thought it would be. Because, again, they're just, and if I could just tie that back to then the legal argument, we've got this whole specific versus general canon if the court believes that they are, in fact, in conflict. And 2202C is far more specific. If you think about how many original mandamus petitions are filed in this court against these 6 constitutional officials, there aren't that many. But you can potentially file mandamus petitions against thousands of governmental bodies under the PIA in district court, making 321 the far broader statute. So in that context, 22002C, if they are in conflict, that is the more specific statute and the one that would control.
Does the OAG have a designated PIO, Public Information Officer?
Yes, we do, Your Honor. Our public information coordinators are what I believe. I think it was Ms.
Okay.
Downey who filed the affidavit in this case.
So I guess, the concern here is, and I'm not saying I'm not in any way commenting on the merits of this particular case, but take the governor's office and somebody submits an open record, a PIA request to the governor's office, and the governor's office has the information but doesn't want to give it up, and says, we've given you everything we've got that's responsive. We've got nothing else, but they really do have more. Does the law not provide any remedy there? If it's one of these 6 constitutional officers?
You chose the governor, and the governor is unique, of course, because
That's true,
he's
yeah.
pulled out. But let's
So
step
say
the comptroller
a
in.
bad AG.
Yes.
Yeah, some other AG.
Well, it would have to be filed in this court, and it would have to concern an issue of law, not an issue of fact. I mean, we are, the PIA is a wonderful tool for people to learn about the government, but it's not unlimited. It is
But
limited.
inherently, the issue of fact is, are there documents that are responsive that they're not giving us? By nature, that's the nature of the dispute.
It is.
So your answer is there is no remedy.
In that instance, there may not be.
Yeah.
But that doesn't mean the PIA, as this court recognized in Stetson Renewables, we do assume that government officials follow the law. And
So it's a political remedy.
I think in that case, it would need to be. And
What about the declaratory
well,
action
again,
by the district attorney?
yes, that would be an option. I guess I was thinking of the requester having to seek its own relief, but they could then file that complaint under 3215 and see if that would produce, or if that was a viable option to forcing the bad faith governor or attorney general to produce
So
those documents.
you have a local DA suing the statewide AG. That's the only remedy.
That is how the legislature has set it up.
Yeah.
What about an original mandamus petition filed here in the first instance? Would it be a question of law to sort of come to this court and say, could you do some judicial review of our privilege claims? Are those legal questions? And would this court be doing sort of review of the AG's privilege log?
Well, I think it would need to be something kind of similar to what the court did in Sharp, because it was documents they knew it existed, but it's a question of law whether the privilege applies to that. So there are certainly circumstances, and you see
Right,
this
right,
in-
that's what I'm asking you to
Right.
posit.
Right, and so that's what the court did in Sharp, and it found that it did not have to resolve issues of fact in order to resolve the legal disputes that were at issue there. So there are certainly some cases, if we know, for example, that the certain documents do exist and we have claimed a privilege to them, you could review that if you believed it was, wrongfully
But
privileged.
that's sort of the sum and substance of the kind of relief that the requestor could get without going to the DA, for example.
In this court,
Yes.
yes, that would be the limit of it.
Do you think that if the legislature expressly said that the mandamus can be brought by the requestor against the governor, that would be problematic in any way, or would that be within the legislature's authority?
I think that would, with respect to the governor, I think that creates a separation of powers concern at the very minimum, simply because we have, if I could finish my answer, because the Constitution says not even this court can issue mandamus against the governor, it would seem very strange to then say, but any district court in the state can. And I think that just, it suggests to me some separation of powers problems, and I would want to go back to when this constitutional provision arose and see if that was something that district courts naturally did in the first place, or if this was, just sort of a unique thing that they needed to put in there. But I do think it's another reason to perhaps conclude that 321B did not just open the door to issuing mandamus against constitutional
But you think it's an
officials.
open question about whether or not the legislature has the authority to allow a district court to mandamus the governor?
I believe in this court, there was a Court of Criminal Appeals case. Let me see, I wrote
Yeah, I
it.
mean, in this court.
Oh, in this court, I have not seen that this court has ruled on it. I say the CCA, I think, has suggested that no district court could issue mandamus relief against the governor, but I don't believe this court has ruled on that.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Robb will present argument for the respondent.
Thank you, and may it please the court. Petitioners come here today asking this court to ignore the plain language of the Texas Public Information Act. Section 552.321 states that a requester may bring a writ of mandamus against a governmental body that refuses to supply public information, and it requires that any such suit must be brought in the district court where the governmental body is located. Now, in an effort to avoid this statutory language and any meaningful review of their decisions about whether or not to supply public information, petitioners ask this court to rewrite the Public Information Act to completely exclude the governor and, we believe, the Attorney General from any sort of judicial review for their actions under the PIA. This position-
What about the potential to go to the district attorney and complain and see if they'll bring a case for you?
Sure. I think there are a few problems with that. First, as I think my friend here has acknowledged, that only allows the petitioner to go to, as you said, the district attorney. It doesn't provide any sort of direct relief for the requester itself. And if you look at the Public Information Act, it has really good language about the fact that the people are allowed to demand accountability from their government officials. They're allowed to know how their government is operating. It's not, and I don't remember the words that counsel used, but I mean, this is ingrained in the Public Information Act. This is the public policy of the state. And so to say that you have to go first to a district attorney and hope they don't have to bring a suit, first of all, they can look at it and decide not to. If they decide not to, then you go to the Attorney General. In this instance, my clients would have to go to the district attorney, hope they did something. If they didn't, they would have to go to the Attorney General and say, would you like to, require judicial review of your decisions, file a suit against the Office of the Attorney General.
So
we
is
don't-
this suit against Ken Paxton in his official capacity and
It
Greg
is.
Abbott in his official capacity, or is it against the Office of the Attorney General?
I think they're the same. It is styled as against Ken Paxton and the governor in their official capacity. But the
But if you
laws.
look at the definition of governmental body under the PIA, it doesn't include the officers.
So if you look at the definition of the governmental body in the PIA,
A board, commission, department, committee, institution, agency, or office that is within or is created by the executive or legislative branch. It doesn't incorporate, does it somewhere incorporate the officer themselves?
well, suing, I mean, they are the public information officers for those bodies, and suing them in their official capacity is essentially a suit against the office itself. And I think this court in Sharp recognized that. I don't think there was a question about whether or not in that instance, the comptroller could be sued. The question was just, what is the proper court for the requester to obtain mandamus relief? And we believe, and I'm happy to go through it, but we believe that section 552.321B answered that question. If I may, can I give a few more responses first on why we think?
Why do you think that it answered that question? Because it's a venue provision, and it also talks about a requester being able to seek mandamus relief in district court.
Yeah.
But in light of Sharp, the legislature did not specifically name the individuals that are in 22.002, even though it was identified as a problem in Sharp. So why do you think it answers the question about the statutory harmonization between those two provisions, the writ power and the PIA?
Sure, absolutely. Thank you, Justice Bland. So I think, and we have a graph for y'all, or a little demonstrative here that I hope y'all received. And if I can look at this, this may help me kind of walk through this. But in Sharp, and if you see on the first page, the court said any exception to this rule would require express statutory authorization for the legislature naming district courts as the proper fora. And then it went on to say, although we were able to resolve the issues raised in this proceeding, again, because they found that the governmental body and the officer were effectively the same, they said, we encourage the legislature to take another look at the civil enforcement provision of TORA, the predecessor to the Public Information Act. If you look at the next page, this is the act itself. So obviously, we all understand the underlined language is the language that was added. The act originally said that a requester could file suit for writ of mandamus against the governmental body. In adding, after and in response to the Sharp decision, the court clarified that for all governmental bodies, the district court was the correct court, and we believe this conferred both jurisdiction and venue. I respectfully disagree that this was only, I know the state has said that this was just a venue provision, but it specifically said it didn't carve out any exception for the governor and the attorney general. And to be clear, what we're talking about here today is more than just the governor and the attorney general, because as the Sharp court identified sort of these other sort of a slate of officers, and as the state has said in their pleadings, they're actually talking about more than themselves. So when they're asking you to rewrite the Public Information Act, to forget that those people were not excluded, and to say, well, they didn't say that they were excluded from the definition of governmental bodies, but we should exclude them because that's probably what they meant to do. We're not talking about just the governor and attorney general. We're talking about these other officers, and you're talking about issues, including, how the state's money is spent. I mean, if requesters want to go and find out information, and again, hold their government accountable, and find out information about how elections are run, how their public money is spent, how disaster relief is managed. These are all the offices that have this information. And if they are excluded from judicial review, this court is essentially writing in something that says, for them, everyone else, judicial review is great for everyone, but not for these highest offices in the land.
There's I believe it's a Sixth Court of Appeals case that says, in the context of election-related mandamus petitions, where there's a general grant of authority in that regard, that court held that general grant of authority to bring election-related mandamuses does not include authority to bring them against these executive officers who are excluded under 22002. Was that case incorrectly decided, you think?
I think, and I apologize, I don't have it in front of me, but I don't believe that that controls the case here. I think that that case is distinguishable, and I apologize, I don't.
I think it's just about the exact same issue. It just, in that situation, you're talking about election-related mandamuses. Here you're talking about Public Information Act mandamuses.
I think, well, I think.
The question is whether the general grant of authority to issue mandamus relief overrides the specific exclusion of executive officers from that authority in 22.002. And then that court said yes in election mandamuses.
So I think here, first of all, we're looking at statutory.
Or said no, sorry.
Oh, I apologize.
Yeah.
We're looking at statutory construction. We're looking at a later and a more specific rule here. So I think, this is distinguishable because here, again, we believe this was passed in response, in direct response to the Sharp decision. The court presumably was aware of, one, the definition of governmental bodies. It was aware of 22.002C, and in response it said, this is the only place you can bring these actions. They must be brought here, without exception. It didn't change the definition.
The fact the amendment was made in response to the Sharp decision doesn't necessarily tell us anything, right? It just about what the amendment does. We have to look at what it says. And how does what it say override what's in 22.002?
Because what it says is any action for mandamus against the governmental body must be brought in a district court. It doesn't say unless you're unless you're the governor or the attorney general. It doesn't change the definition. I mean, they could have changed the definition either in the first section saying you simply just can't bring a mandamus action against these individuals. And it didn't change it in the second section in B and say, well, you can bring a mandamus action or you're required to bring it in the district court for all of these officers or for all of these governmental bodies, except for these specific 6 or 7 people. It said, must be brought governmental body.
Is there any other example in the law of mandamus being authorized against the governor?
I apologize, I didn't hear the question.
Is there any other example in our law of mandamus being authorized against the governor?
I don't know, Your Honor. I don't know. We do think, though, this here is a very narrow carve-out, and it's very specific because, again, we're not asking the governor to take any, wild actions. This is not, as my friend has said, there haven't been a whole bunch of mandamus actions here or in the district court, people asking the governor to take some action.
Do you agree that it's at least a serious question about whether the legislature has the authority to allow mandamus against the governor in any court?
Yes, but we think here, again, this is for a very narrow sliver of things. This is simply saying...
But if it's a serious constitutional question and we have text that doesn't compel your reading, doesn't the normal course of the judicial process direct us to resolve the question against the reading that would engage the constitutional issue?
I think here the text of the Public Information Act says that it should be liberally construed to effectuate the release of information. It should be liberally construed to effect its purpose. And here, there's only, I think, we don't think you need to liberally construe this to understand that these bodies are not exempted. But if for some reason it seems like this is a toss-up, we think that the Public Information Act very clearly says it should be liberally construed in favor of its policy. And the policy is very strong. It's in favor of allowing the people to be the ones, and if I can just read there's the great language in the Public Information Act. This is in the beginning. It says, the people in delegating authority do not give the public servants the right to decide what is good for the people to know and what is not good for them to know. But that's exactly what...
Well, nobody's disputing, I think, the substantive obligation of these governmental entities and individuals to comply with the law. They're questioning whether or not a judicial remedy of this sort is permissible. And those are two very different things.
Well, they are, but simply saying, trust us, we've we've done the right thing. I mean, simply, and they admit they're subject to the Public Information Act. So simply saying we're subject to the act only gets you partway there.
But don't we have
There's not any
cases that go
enforcement.
on and on and on about the presumption of regularity on the part of the other branches that helps us to avoid separation of powers conflicts unless they're absolutely necessary? So I take the point that just trust us maybe doesn't sound very good, but the opposite point of we can't trust them. We must engage the judiciary against the highest executive official in the state that, as far as I know, has never been subject to any mandamus action of any sort. That seems the opposite. We're rushing towards a constitutional conflict instead of trying to apply a statute in a way that avoids needless friction.
Well, I think, respectfully, I think the opposite is equally as disturbing. To say that the highest officer in the land is beyond review. And
Well,
I think
That's
so
not
to
at
get
all
back-
what this, I go back to this district attorney provision. I mean, it certainly is an extra roadblock for you to have to go that route, but it's not at all the case that there isn't a remedy, and it doesn't, why would it be so surprising if the way all of this works is that for this category of, elected constitutional official, we're not gonna allow, any requester to drag them into court. We're gonna make you go ask the district attorney and see if that person agrees. So there's just an additional layer of review before these constitutional officers can be hauled into court over an issue like this. Why is that such a strange or unfair arrangement?
Sure. Thank you, Mr. Chief Justice. I have a few other responses. I know I started with this earlier. I think one is that simply getting declaratory judgment isn't sufficient. What the people demand is to actually get access to the information. To say simply, you shouldn't have refused to provide that information is an incomplete remedy.
Well, why couldn't the declaration be, this isn't exempt, you've got to turn it over?
Well, it could be, but that still doesn't require them to actually turn it over. I mean, they could say, you incorrectly withheld it, you should have turned it over. But,
Well, that's why 3215 allows injunctive.
Injunctive relief.
well, and so I think,
Not only
there's a
that.
problem with that as well. I still don't know that injunctive relief, I mean, there is a difference, and the courts recognize this, and this
Will
may be
you
why
help me
there's a
put
mandamus
this
provision.
into context? So let's say the governmental body at issue is a city, not a state agency or a statewide elected official. The way the PIA works is if your client submits a request to the city, and the city thinks we don't have to, this is privileged information, or it's, we don't have to produce it, they're required to ask the AG for a ruling on that, right? And if the AG says, yes, you have to release it, then that's when 321 kicks in. If the governmental body either refuses to ask for an AG ruling or gets an AG ruling saying you must release it, then 321 says you can mandamus them. What if the AG, this is where I know that the Act addresses this, I just can't remember how or where. What if the AG says, no, you don't have to release this? You're right, it's privileged, it's confidential by law. Then what is the requestor's remedy then to challenge the AG ruling? Is that 321 or
That's
is that?
I apologize.
You think that's 321?
That's 321 exactly. If you read it, it says, or refuses to provide public information. And this court in Callanan talked about this problem, which is that, by.
No, it's refuses to supply public information, refuses to request an AG ruling or information that the Attorney General. Okay, so you think if the AG says you don't have to release it, 321 is what allows the requestor to challenge the AG ruling in essence?
Absolutely, Your Honor. And that is actually one of the other issues in this case, and I appreciate you bringing that up because I do want to just address that briefly. Putting aside the jurisdictional questions in terms of, whether or not they're subject matter jurisdiction, the other big issue here is obviously the state's claim that sovereign immunity has not been waived. And for sort of inelegantly, there's sort of two pieces to that. But part of that was we the mandamus action was filed in response to the refusal to provide complete public information, and that's public information that they refused to provide based on an AG decision. We think the law is pretty clear in Callanan that says that you can get one. The AG's office actually thinks that, and if you look at their website and at their AG handbook, they actually state that that is exactly what the requester is allowed to do. If you get an adverse AG ruling, you can file a mandamus action under 552.321. There's one additional piece to that, though, which is that the Public Information Act in 552.323, I believe, provides that the prevailing party in such a suit can recover attorney's fees. And it specifically says that the state is not required, the governmental body is not required to pay the attorney's fees if they relied on an AG opinion. So that language would be completely superfluous if you couldn't actually challenge that.
That's the distinction between 2 and 3 of A, is that what you're saying? Because 2 says a refusal to supply public information, and 3 says a refusal to supply information that AG had determined is not accepted. And so what you're saying is, even if the AG says it is accepted, you can still sue under 2?
Yes, Your Honor. Yes, Your Honor. And again, the Attorney General's office themselves tells other governmental bodies, it tells requesters on their website and in their PIA handbook that that's what requesters are allowed to do. So this is not, you don't have to believe us. You can believe the Attorney General's office when we say that. And again, as I said, the statute also says that. I had one other issue, and I apologize that I have now.
Do you have a theory on why the legislature would have called this a mandamus action if it didn't intend to incorporate these sort of arcane and unusual limitations on jurisdiction?
I think they were cognizant of what the law already said, which was that governmental bodies can be sued for mandamus when they refuse to provide information. And again, the Sharp court didn't say, or this court in Sharp, I should say, didn't say that those bodies weren't subject to the act. It couldn't be mandamus. It just said and they specifically said, under 321, we're asking the legislature to clear up where that suit should be filed. And so I think with complete knowledge of the definition of governmental body, the legislature added in the language. They didn't put an exclusion. The state now is asking you to write in an exclusion, but there's no exclusion if you look at the clear language. It says governmental body, no exception. It doesn't say except for. And so we think this was the natural response. This was an easy fix. I see I'm out of time. If I can just quickly say, if you can indulge me for 1 minute, I just want to read one other thing. This is actually from the Attorney General's Public Information Handbook, and it says, the Texas Public Information Act assures the government entities give citizens access to information about the business government officials are conducting on their behalf, information that enables the people of Texas to observe how their government works and to hold their public officials accountable. Texas government does not belong to elected officials, but to the people. As we stated at the beginning, we think the PIA clearly sets out the process a requester must follow to challenge a governmental body, any governmental body's decisions on whether or not to supply complete public information. Respondents here followed that process, and we ask this court to reject petitioners' request to rewrite the PIA and to affirm the lower court's ruling denying petitioners' pleas to the jurisdiction.
Any further questions? Thank you, Ms. Robb.
Thank you, Your Honors.
Ms. Klusmann, I believe you have 5 minutes.
Thank you. One point that I had intended to make in my opening but didn't get to is to give some value to the word district court in 321B, because I think that's, of course, what a lot of their argument hinges on. It identified a district court. Well, county courts at law, if you look through Chapter 25 of the Government Code, there are about 13 of them that are given concurrent authority with district courts to the constitutional and statutory limits of those courts. So in those counties, there is concurrent jurisdiction between county courts at law and district courts. And so by identifying district court and 321B, the legislature may very well have been saying, well, in those counties, you need to pick a county court of law, not a district court. And that gives value to that language without having to bring in these 6 constitutional officers that are subject to 22.002C.
In
So,
three,
I'm
go
sorry.
ahead.
They say 321 applies even though they named the officer in his official capacity, because that's the same thing as naming the governmental body, and therefore 321 applies. And your response to that, it seems to me, is twofold. One is, no, that's incorrect. You have to name the governmental body. But two, even if you did, there's no waiver of sovereign immunity here, and it is in effect a suit against the officer, and therefore there's no mandamus. Constitutionally, mandamus is not permissible.
I think I followed that, but yes. I mean, if you just look purely at the text of the PIA, as we've noted, they define governmental body in a way that does not include officers. They have never changed that.
So 321 has to be a suit against the governmental body, not against the officer.
According to the legislature.
Does it really say that? I mean, it says that the requester may file suit for a writ of mandamus compelling a governmental body, but it doesn't say it has to be naming the governmental body. If you name the executive officer, the person who's doing it, that will compel the governmental body to do it.
That could be a fair interpretation, Your Honor, I guess.
I mean, don't we have cases that go all the way back that say that if you want to name the city or something like that, you have to also name the official who can take the action that would be targeted? We don't really have a long tradition of mandamus that targets only a non-human entity, do we?
Not to my recollection, Your Honor, but I confess I have
Is
not.
that you need a human to be, the officer itself to be named. So I mean, maybe they should have also named the governmental body, but that's not really a big part of your argument, is it?
It's not. It's just a way to read the statutes as not being in conflict. Like, they technically aren't in conflict, even though in practice, perhaps you would normally name the official instead of the governmental body.
So did I hear you say that in a county with concurrent jurisdictions for county courts at law, a PIA action would be appropriate in a county court at law, even though the statute says district courts? Or
No,
did you say the opposite of that?
It was
The
intended to be
opposite,
the
okay.
opposite.
So,
that
so
prior
your
to
position
the-
is that even though, this court is a court in Travis County that has mandamus jurisdiction, at least against the Attorney General, it is not the appropriate forum for a mandamus action under the PIA, because that has to be brought in district court. So the only remedy is that the complaint process with the local county or district attorney.
With respect to, I guess, there are so many moving pieces. With respect to the governor, you do not have a mandamus option.
Right, that's
With
right,
respect
as
to
Attorney General.
Right. With respect to the Attorney General, you have the 3215 option, and you have original jurisdiction in this court. Now, my point with the county courts at law is that could have been a reason why they specified district court in B. So for all of the other thousands of governmental bodies, perhaps some of them could have been subject to suit in a county court at law, and B says, no, you need to bring that in
Well,
the
but
district court.
how could there be an original, let's say it's the comptroller, how could there be an original mandamus into this court when B says you gotta bring it in district court?
Because in that case, you would have that conflict. You have 22002C, which says only the Supreme Court can issue mandamus relief against the comptroller, and then you have to decide, well, does B require something different? Does B, if they conflict, then you go through that specific versus the general to figure out which one the legislature intended to control over the other. But if you read B to say, well, it has to be in district court, and you read 2202C to say it has to be in the Supreme Court, then you've got that irreconcilable conflict. Now, I've offered some ways to avoid that by focusing on the officer versus the governmental body, or construing the reference to district court to limiting suits to district courts as opposed to county courts as law. So you wouldn't have to presume that the legislature conflicted with itself, but that those would be the options for interpreting Section 321B as we see it.
So is your position that this court does not have jurisdiction to entertain a mandamus under the PIA against one of the enumerated state officers?
No, this court does. That's what the Sharp decision
You think that
said.
there's no preclusion under 321B by naming a district court from this court hearing a PIA mandamus?
Correct. I don't think 321B interfered in any way with 2202C.
I heard your friend on the other side to think that might be what you were.
If that is the impression I gave, no, 2202C is still in full effect for all constitutional officers.
So if it's filed in the district court according to subsection B, which seems proper, would the district court have an obligation to try to transfer it to this court if it's not against the governor?
For I guess, the remaining 5 constitutional officers, I think the appropriate thing is to grant the plea to the jurisdiction and dismiss it. And then if they wanted to attempt to refile here, they could try that.
Any further questions?
I have just one. How does your interpretation give meaning to the part of 321A that talks about a refusal to supply public information as distinct from a refusal to supply information the AG determined is not accepted? When could you sue under your theory for a refusal to supply public information that doesn't involve the AG saying you got to turn it over and you don't?
I think that is what Ms. Robb correctly stated, is if the Attorney General says you get to keep it, it's still deemed public information, it's just withheld as privilege. So you would sue under that second section and say, well, that's public information that I think the Cox.
Well, the AG determined it was not accepted. That's a separate part of 321A. It has
Right.
it has 3 parts: to refuse to request an AG decision, refuse to supply public information, refuse to supply information the AG determined is not accepted. And
Right,
so
so
your
if the-
hypothetical is the last one, that the AG determined it is accepted.
No, if the AG determines, if I'll just say, I'll use privilege because accepted I think might be confusing. If the AG says it's privileged and you get to keep it back.
Right.
That's the third part.
Right.
Right. If the AG says, or no, sorry.
No.
That's the second part. The third part is if the AG says you have to turn it over and you refuse to turn it over. That's when you file that mandamus petition. If the AG says you get to keep it back, part 2 is what kicks in and says that's actually public information that you have to turn over. That's how I understand the court's decision in Callahan.
You agree with the friend on the other side that 321 is the procedural mechanism for a requester to effectively challenge an AG decision?
Yes, I think that's what the court
That's
said
the
in
second
Callahan.
part. Yeah,
Yes.
sorry.
Any further questions? Thank you, Ms. Klusmann. Thank you to all counsel. The case is submitted, and the court will take another brief recess.
All rise.